Good morning, Ms. Mogwera.
Good morning, Justice Maya.
Did I pronounce your name correctly?
Yes, it's Mogwera.
Mogwera, I'm sorry. Yeah, I suspected I might be doing something wrong. Okay.
Motswana.
Ah. Well, I'm Xhosa, so I
Yeah,
pronounce names as I
would
see
expect that
them.
you'll say Mogwera.
You have 3 law degrees, a BUris, LLB, and LLM.
Yes, Justice Maya.
And I just found it very interesting that you've obtained each one of these qualifications 10 years apart. The first one you obtained in 1990, then 10 years later it was the next one.
Yes,
and
in
another
fact,
10 years later.
it's a
it was
pity
another
that in
one.
2020 I did not get anything.
Indeed. You started your legal career in the Department of Justice. That's where you cut your teeth. And you had been a clerk and then became a legal administration officer. What did you do as the administration officer?
During that time, it was in the then Bophuthatswana. I was working in the company's office, deeds office. It was one office. And I worked with, in the office of checking the trademarks, the copyright, the registration thereof, checking compliance with legislation. I would also assist with, in the company's office, registration of companies and do some stints also in the deeds office.
And 5 years later, you became a prosecutor.
Yes, Justice Mai.
And after another 5 years, you became a magistrate
That's correct.
and made your way up to regional magistracy, where you are now.
That's correct, Justice Mai.
Where are you stationed?
In Pietermaritzburg.
You have acting judicial experience in that division. That is where you have acted as a judge, not so?
That's correct, Justice Mai.
And when did you do that?
Hey, it's from time immemorial, since 2009. I was just having a discussion with one of the candidates saying I'm so unfortunate because I would just get one stint here, one stint there. I have been doing that intermittently since 2009.
And how many acting stints have you had to date?
If I'm correct, it would be about 33 weeks or so.
And what kind of work have you done during those stints?
In the main criminal work, I think the last 2 stints, it's when I did some civil work. I was in the motion court.
Was that for the first time?
At high court level, yes.
Yes. All right. So would you consider yourself as experienced in the area, in that area?
Of civil work.
Yeah, in the high court.
No, in the high court, I would think that I would be able to cope. I coped very well when I was there. And since 2010, when the regional courts were given civil jurisdiction, I was there from that period until around, I think, the end of 2020. So I noticed that the work is very similar. It's just that the rules differ in there, and there are some things that some issues, legal issues that I only met for the first time in the High Court.
Yes. You have produced written judgments in the High Court.
Many criminal judgments, I can't count those. and about 6 or so civil judgments related to motion proceedings.
Any of those judgments reported?
Not that I'm aware of.
Okay. Have you been taken on appeal? In the High Court, that is?
Civil judgments. I know.
On any?
No, yeah, most of my judgments, the criminal judgments that go on appeal, let me say about 95% of them, they are confirmed on appeal, and 5% would be disturbed maybe when it comes to the issue of sentence. And the civil judgments, I'm aware that 2 of my civil judgments that were taken on appeal the appeal was dismissed.
Yes, you mentioned 1, 2, well, 3, no, 2 that were upheld and the rest were dismissed. Okay. The partly heard matters you listed in your application form, what is their status? Has there been any
I
movement?
think about 3 of them have been finalized. 2 of them are at a very advanced stage, like I'm closing argument stage, is the criminal matters. And the one reserved civil judgment, it's still reserved because when I had to give a judgment at, I think, mid-September, one of counsel was involved in an accident and he was in a coma, he couldn't come. So they were still going to make arrangements, I think for the plaintiff, to make arrangements for somebody to come and stand for him. So the judgment is ready, it's just waiting for him to be available.
The one reserved judgment you mentioned in your application form, has it been delivered?
That's the one I'm talking about.
Oh, all right. When last did you act as a judge, that is?
It was January this year.
Okay. The law bodies have, well, you have been through this process before, and you know that the law bodies send in comments on candidates, and in one of the comments on you, this record is just unraveled now. I think it's the GCB, yes, has raised concerns about your candidature. In fact, it's not fresh concerns, it's matters that were discussed with you when you were interviewed last year. The charges that you take too long to hand down judgments in the regional court where you are permanently stationed, and that you did not start court on time and would adjourn early, and that you absented yourself from work. And they do note that you actually addressed these concerns in 2021, but still felt the need that they should be put to you again. Would you like to respond?
My response, Justice Meyer, will be the same as last time, for the benefit of the commissioners who were not here. Let me just start by saying, I noted that it's only the GCB. Last time there was also Advocates for Transformation. I did not see anything from them this time around. The issue is, I explained about the 2 matters that they raised, the 2 judgments. I explained the issue of the challenge that I came across resulting from the files that went missing. That is what contributed to me taking too long to hand down those judgments. I still stand by the submissions that I made last time. The issue of not starting court early, punctually, like I said last time, when it does happen that the court doesn't start on time, there would be good reasons, which would be circumstances beyond my control, as I'm sure that we are all aware of the challenges that we come across in the lower courts. I specifically alluded to the fact of awaiting trial detainees who are brought to court late on what I can say a very regular basis where I'm stationed. There are infrastructural challenges that we come across when the machine is not working in the morning due to load shedding. It's no use going to court at 9 o'clock only to come out and be told you have to adjourn because the machine is not working. Those are the factors that would contribute, and it's not even a regular thing, which I did indicate last time that I take it as unfair criticism. The one that hurts me the most is the one where it said that I absent myself from work, I adjourn early. There is absolutely no truth to those allegations. And like I mentioned last time, the advocates in the lower courts come occasionally. The only advocates who come frequently are those that we say are from the independent bar. Those are the ones that you'll see from time to time. And they do not belong to the GCB, I suppose, because I'm sure they would vouch for me. It hurts me because it gives a picture that one does not take his or her work seriously. And it is unfair criticism. My leave record is there, it can speak for me. I'm the type of person who would go to work feeling very sick, to an extent that my colleagues and my court staff would ask me, why did you come? Now to be told that I absent myself, to me going to work has gotten, I'm not being pushed, I love what I do. I go there, I'm looking forward every morning to going to work. On very regular basis, there are cameras where I'm working. I leave the office after all people have left because I want to keep myself busy with something, do my judgments or do something, do research. I love doing research. And I would sit in my chambers until around 6, 7. By the time I leave, it would be dark outside. Now to be told that you adjourn court early, you leave, it's really unfortunate. And there's absolutely no truth to those allegations, like I said. All the other bodies, the attorneys, people who I get to interact with on a daily basis, I'm sure they can vouch for me. They have also made submissions, and there is nothing to that effect in the submissions that they have made.
Do you know if these concerns were ever raised with your judge president? Were you reported to the judge president at the material time?
I have been in Pietermaritzburg since 2004. Not once was I ever called by any regional court president to be, and never once, even, you know, it's very surprising because from the time of Judge Vuka Chabalala, Judge President, he was the first Judge President to invite me to act in the High Court. I'm sure that if there were such concerns, because after him, all these judges president who came after him, they kept inviting me. I'm sure that if there was any legitimacy or validity to what is being said, I take it that they have a responsibility. They should have brought it to his attention and all these other judges president, that how you are inviting a person who doesn't have a work ethic at all, because that's how I am portrayed. And I have to say again, there's no truth to those allegations. And the other thing, when you don't have specifics, it's very difficult for you to even respond, because there's no one who said on a certain date I arrived, the court had not started because of the magistrate who had absented herself or who had decided that she would come to work very late.
Yes. No, thank you very much, Ms. Mogwera. JP, do you have questions for the candidate?
Yes, thank you, DCJ. Morning, afternoon, Ms. Mogwera. How are you?
Afternoon, Judge.
How
Judge
are you?
President, I'm very well, thanks. Thank you, Judge President. How are you?
I'm fine, thank you. Thanks for asking. I see you were born in Ghanesa.
Yes, Ghanesa is my home.
Yeah, but I don't know whether we have met.
We have met, but I was a litigant during my, I think, let me just say, during my divorce proceedings, you are the one who.
I
Granted.
divorced you. That needs to be declared, DCJ. Yeah, but you never acted in the Northwest High Court.
Yes, I have never acted in the North. Actually, the last time I was in court in the Northwest is when I was a prosecutor. I left in 2000, and I went to PE, to work in PE in 2000.
Okay. So, why do you want to come back to the Northwest now? After 20 years.
Judge President, if you were Motswana, you'd understand. I was going to put it this way. I think it's time for me to go back home. But
Okay.
besides that, I think I have made my contribution wherever I have been. Like I indicated, I worked in the Eastern Cape in 2000. I was there. From 2000 to mid-2004, then I went to KwaZulu-Natal. At that time, I had it in mind that this is a new South Africa, I need to embrace it, and there's no need for me to be confined here. I need to spread my wings. That's why I decided to go there. And I think age has caught up with me. Not only that, the big thing, if really, my personal reasons, would be that my mother is now in her 80s, and my sister, I have a sister, in fact, let me just explain it. We are 4 at home. I have 2 brothers, they are unmarried. My sister is blind. She's staying in Mafikeng. I also have a house in Mafikeng. That's my own house. My home is in Ghanesa. And these 2 people need me the most. They have really appealed to me to consider coming back home. Because my sister doesn't have children. Let me say she has 1 child, a boy who stays in the streets, and if he's not in the streets, he's in prison. Yeah. And my mother, being an elderly lady in her 80s, they need me. My sister's husband died in 2018, the person who was looking after her. So every time they get sick, I have to drive from Pietermaritzburg to go to the Northwest, get them there, and take them to be with me, because so that I can be able to look after them while they get the necessary medical care. So that, to me, is the main reason. And I also want to work at home. I want at least the people of the Northwest, people of Mafikeng, must just get a bit of whatever is left in my skills to serve my people. I'm not, by this, I'm not implying that the KwaZulu-Natal people and the Eastern Cape people are not my people, but I'm sure you understand what I mean.
Yes, thank you. The last question. I've listened to what you said about the exposure that you had in the High Court as far as civil work is concerned, especially motion court. It seems that you did 6 matters in the High Court.
Opposed motion, yes.
Opposed motion.
It's
Now,
not 6. I think about 2, in 2 matters I gave extempore judgments because I had prepared.
Yeah. But most of the role in the High Court Northwest consists of civil matters, mostly. Don't you think that you still need to get more exposure and more experience?
Judging from the 2 stints that I say I've had in in the civil court, in the High Court in Pietermaritzburg, I believe that I can cope. Because I would say it's not only those civil cases, that was opposed motion, but when it comes to motion court, you have to prepare every file. And in Pietermaritzburg, you get about 30 files when you have to go to court, and you go through all the files.
Have you ever, have you ever done a civil trial in the High Court?
I haven't done a civil trial. I only did a divorce trial, which I've finalized.
Yes,
But I must, can I also indicate, JP, that I've done a lot of civil trials in the regional court, which are not very different from the trials that I've seen. The only area of the law where I would say I would have maybe some challenges are those matters that we do not deal with at all in the regional court. I believe that my competence to do civil trial, I think I am competent to be able to do a civil trial. As I say, for about 10 years, since 2010, I've been doing mainly civil work in the regional court.
Yes. Thank you, DCJ.
Thank you, Judge President. Premier, any questions?
Just one question from my side. Dumela me Mogwera.
Dumela ra le kae re mape?
Ke a utlwa o tswa Phohung.
Ke a itse o tswa ko Phohung, nna ke tswa ko Khuti,
Oh, wena o tswa ko Khuti.
ko Chief Block,
Okay.
ko ga Musiane.
Okay. The Northwest being a very vast province and being very rural, and sometimes there's a sense that the courts do not reach people in far-flung areas like Bray and so on. What do you think you would contribute to ensure that you make the court available to people in those far-flung rural areas?
Thank you for the question, Premier. I think it is a very valid thing. In fact, I was just thinking about it now. I was thinking about people coming as far as Bray. I even calculated, I checked, I Googled to see the distance is about 300 kilos. And I was thinking to myself, it's better when the court is taken there to the people. But the challenge, the big challenge that with the Northwest that I have picked up is that it's the criminal courts that go on circuit in the High Court. People, the court is taken to the people. But I'm thinking of a situation where a litigant has to travel for more than 300 kilometers to reach a court in Mafikeng, and I don't think that is right. So, as somebody who, if I happen to be considered, the only thing I can do is to appeal to the Judge President and maybe give some suggestions as to how this can be done. I do not understand why there has to be only one seat, because really it appears that the powers that be are not considerate to the rights of the people. So the only thing, because I think in my capacity, there isn't much really that I would be able to do, but just to appeal to the powers that be and plead with them to consider having maybe a second seat in that part of the province. I'm thinking also about the other part of the province, Taung, and the areas surrounding Taung. As far as I'm concerned, it's also far for them to travel to Mafikeng. It really boggles mind why there would be only one seat. But with the criminal courts, I don't suppose there's a big problem, because I know that the judges do travel to these far-flung areas. But that's what I would do, and I would do my best to try and pursue it and persuade and make a lot of noise to the ears of, if I have an understanding JP who would be able to allow me to make noise to him. And perhaps knock your door every day and say, Premier, do something.
Thank you, Premier. Commissioner Nyambi?
Thank you, DCJ. Afternoon.
Good afternoon, Commissioner Nyambi.
One question from my side. The interviews that we held in April 2021, any other thing after hindsight, proper reflection, that you might think you haven't done justice to yourself, that you might want to correct today? Linked to that, probably some significant changes to the person that we interviewed then that you think you want to bring to our attention so that we can seriously consider this time around?
Yeah, I did a very serious reflection, Advocate Nyambi, after the last time. Okay, the first change that I would perhaps highlight, when I left here, the following day I was in court. The first thing, I found my court staff waiting for me with, they had a book, because I had indicated in that interview that when the files got misplaced, my notes were in the file. I had that habit of writing notes in loose pages and putting them in the file. So I remember very well that Justice Maya suggested to me that I should consider buying myself my own books where I would keep my notes. So I found it very interesting that my court staff who were watching the interview, I'm sure even today they are watching, they had bought me a book. So now I'm keeping my notes very safe, and I'm very particular with knowing where my work is and not leaving it. I have done very serious reflection, as you have indicated, and I've told myself that, whatever excuses that people can have, I know that you will never be able to please everyone at all times. But I want to do I told myself that I want to do my best to give people that impression, who have that impression about me, that in fact I'm not that type of person.
Thank you, Ms. Mogwera. Thank you, DCJ.
Thank you, Commissioner Nyambi. President Betze?
Thank you, DCJ. Good afternoon, Ms. Mogwera.
Good afternoon, Justice Betze.
I have only one question for you, and it relates to one of your judgment. It's an appeal judgment had in Pietermaritzburg. Mbongeni Sitole versus the state is at paginated page 38 of the bundle. Please let me know when you get there so that I can proceed and pose my question.
Yes, I have it, Justice Betze.
Okay, by all accounts, this is an appeal judgment from a judgment of the Pietermaritzburg Regional Court.
That is correct,
But-
Justice Betze.
There's no indication from the face of that judgment who the second judge was. Did you sit alone in that appeal?
No, I did not. Might have omitted to put, I think I was sitting with, Judge Poyo.
But as I say, there's no indication that
Yeah,
you sat with
there were-
another judge and that whoever you sat with
There were some judgments
is
that-
aware of that judgment and co-signed it.
Oh, yeah, no, I see, I see your point, but I think I was sitting with Judge Boyo. There were some judgments that I printed from my laptop because I had asked that, I went to the High Court to try and get some judgments. I could only get some. And others I did not get, so I got them from my laptop. But as far as I can remember, I was sitting with her.
And did you run through all the judgments that you wanted to attach to your questionnaire? Because if you had done so, you would have picked this up.
I would have, but seemingly I did not pick it up. But as far as I can remember, I think I was sitting with her. If this is the judgment of negligent driving, I think I was sitting with her.
I take it that you are aware, of course, that in terms of the law, appeals, be it civil or criminal, from judgments of the magistrates court must be heard by two judges. in the
Yes,
High
I'm
Court.
aware, Justice, but
Thank you.
Thank you.
I have no further question, DCJ. Thank
Thanks,
you.
Justice Spitz. Commissioner Moimang?
Thank you, Deputy Chief Justice. Good afternoon, Mayor Mogwera.
good afternoon, Commissioner Mwimang.
Just one question from my side in relation to the matter between Hlala and Dlamini. I think it was on the it was brought in terms of the Prevention of Illegal Eviction from Unlawful Occupation of Land Act. Can you remember that judgment?
Yes, I remember it.
I'm impressed in terms of how you dealt with the matter, particularly given the issue around the insecurity of tenure, particularly to the rural dwellers who found themselves trapped under the communal land ownership. What is your view in view of the fact that the Concord has also made a pronouncement in terms of the manner in which Ngonyama Trust has dealt with the matter of land occupation in that area? And do you feel vindicated by your judgment? Thank you.
I did not get the question clearly, Commissioner Mwimang.
I'm just saying that in view of the Concord pronouncement on the work of the Ngonyama Trust, do you feel vindicated by the judgment that you gave in this matter?
And I wouldn't want to say much about, I know it's a very sensitive issue in KZN, the issue of the Ngonyama Trust. But let me just say that at the end of the day, everything that we look at, we have to look at it through the prism of the Constitution. As much as the traditional authorities are it's a very good institution for us to have as South Africans. Even the way they conduct their business has to be in line with the Constitution. By this, I'm not saying that it is wrong for the traditional authorities to be the owners of land. But at times, there are some of our cultural practices that are still a little bit discriminatory. Like in this case, I observed that the only reason why this lady had to vacate, was required to vacate, because that was the application that was brought by the person who was claiming to be the lawful possessor of the land, is because she was no longer married, and there is that belief that because she is no longer going to be belonging to this family, she has no business continuing to reside there. So I'm just saying that I'm glad that the Constitutional Court has made that pronouncement that you are referring to.
But do you, in view of the dual ownership regime, or the dual property regime in South Africa, which secures property rights of those that live in urban jurisdiction, and the lack of security of tenure of those that live in areas under the traditional leadership, it's a matter that has to be given attention to, because it's unfair that after 27 years, people that are living under communal land ownership still do not enjoy the property rights as guaranteed in terms of our Constitution. Thank you.
I agree, Commissioner Mwima.
TCJ, could I make a follow-up on this? My question was also related to the same judgment.
Yes.
Thank you. Good afternoon,
Good afternoon, Commissioner Ngogaito.
Ms. Mogwera. Could I just ask you, so the response you've now just given, that the basis for the eviction was the marital status, that she was no longer married to the person that she had been married to, and therefore the new possessor came and attempted to bring PI proceedings. Did I get that correctly?
In fact, what happened in that matter, Commissioner Ngogaito, the respondent was married to the son of the applicant, and that marriage came to an end by way of divorce. And what happened was after they got married, they built a house on the land. And upon the dissolution of the marriage, they came to the magistrate court, which granted the dissolution of the decree of divorce. And the issue of the house, immovable property, was not entertained. In fact, they had a settlement agreement whereby it was agreed that the issue relating to the house would be referred to the traditional authority where the house is situated, to be decided by the traditional authority. That was in terms of the agreement, the settlement agreement. And to cut the long story short, what happened was there was a meeting where the matter was not finalized. According to in fact, there's a dispute as to how the matter was finally resolved in that meeting. But the reason why they came before me is because now the person who was claiming that the land belonged to him, being the former father-in-law, said that she is in unlawful occupation, that is the lady now, because there was never an agreement that she would continue, she would remain being there. In fact, she never had permission to remain there because he had given the land to his son, and there was a condition that the respondent will reside there for as long as he's married to the son, something to that effect.
Yes, no, I understand those facts. I was just looking for the jurisprudential basis for the judgment. But nevertheless, let me ask you something else.
I might have misunderstood your question.
No, that's fine, no problem. I don't think you have. I want to ask you something else about the judgment. On whose name was the permission to occupy registered? Because I couldn't work that out from the judgment.
There was a permission to occupy, which was only given to the applicant in 2016.
Yes. So the respondent did not have a PTO in their name.
The respondent did not have a PTO, but the requirement of the requirement that there should be a PTO, according to the evidence that was led there, only came later. In other words, at the time when they took occupation, the husband and wife, there was no such requirement.
Yes. Yes, well, and then also what is confusing in the judgment is when you make reference to that dispute, there's a case, another case you referred to, which involved two separate church institutions, where you say, my understanding of the basis for the judgment is that a lease concluded under the authority of the Ingonyama Trust Board does not trump a permission to occupy. But the problem is that the facts do not show that she had a permission to occupy.
According to her, although she did not have a PTO, the land had been allocated to her. That's where I say there was a dispute. The land had
Yes.
been allocated to her and her husband.
Yes. No, I
That was
understand.
her case.
No, I understand. That's what really strikes me with it, is that it seems that there was, in fact, a different basis on which you could have reached the same outcome, which is either, as you say, a discrimination case under Section 9, alternatively, a customary law case. But if you had gone the customary law route, then you would have had to assert her entitlement as a woman in customary law to occupy the land. But you went a different direction, which is not supported by the facts, because the direction you took was an ITB lease doesn't trump a PTO. But there are no facts upon that.
May you kindly refer me to?
What do you want me to refer you to?
Refer me to where you say I made that finding.
All right, let's do this now. Yes, so your judgment is at page 46. You've got it?
Yeah, I've got the judgment.
Yes, so now
You can
let's...
just refer me to the relevant paragraph.
Yes, that's fine, I'll do that now. So the legal analysis starts at 55. Actually at 56. Yes, it's in paragraph 38 at page 60, where you refer to the 12th Apostles' Church decision, which you say enlightens you in the approach that you should follow. But that's a case where there is an existing PTO, and your case is not one where there is an existing PTO of the current occupier of the land.
I'm sure I approached it from the fact that he was asserting that he has a PTO, and I was saying what weight should be attached to the PTO. That's why I say in that court, in that case, the court held that the pre-existing rights of occupation held by the one church group which had the PTO. Can I just read the whole thing so that at least you can get the light of what I'm saying?
Yes.
In that case, there was a dispute between two church groups over the right to occupy land. The first group, having held the land in terms of the PTO, obtained prior to the second group. The two groups had the PTO. Then the court held that the PTOs of pre-existing rights of occupation held by one conclude, that is the first group, cannot be infringed upon or be overridden by the leases concluded later with the second group. Remember that in this case, the PTO that we are talking about was obtained after the respondent had been given whatever he said she got. It's not necessarily a PTO, but the permission to reside there.
Yes, no, I accept all of that. All I'm saying is that I think the outcome is probably correct, but I worry about its jurisprudential soundness. Because if you look at paragraph 40, there the respondent neither has a PTO nor a lease concluded with the ITB. But you then come to the conclusion that an ITB lease doesn't trump a PTO. So a reader is under the impression that you are talking about a holder of the PTO and a comparison between the relative strength of the rights of the two, whether it is an ITB lease or a PTO. But you are in fact dealing with a respondent who has neither. And that is where I wonder whether a better, jurisprudentially stronger basis for coming to her rescue wouldn't have been customary law rights under IPILRA, which you cite at the beginning of the judgment but never follow through. Alternatively, a discrimination claim, and that's the only point I want to put to you.
The last portion of the judgment, considerations of justice and equity, that's where I dealt with the latter, what you have referred to, the equality. That's where I dealt with
Yes, but
that
that was on justice and equity. You were here dealing with the analysis of the respective rights of the parties, and that's what I'm asking you about, where you ultimately concluded based on this 12 Apostles' Church. But anyway, I've already asked you enough about that. You've given your answers. There's a second question I want to ask you about. Why did PI apply to this land? Because PI ordinarily applies to urban and peri-urban land, and this looks like it's rural land.
That's something that I raised with both counsel, and let me just indicate that they were both represented by advocates. I raised this just from the very onset before we started. That's the query I raised. They said the counsel for the applicant said he could not rely on PI or on Esther because the whole basis, the whole case of the applicant is premised on the fact that the respondent is in unlawful occupation. And Esther does not cover unlawful occupiers. It would mean that that's what, I was convinced, and they both agreed, let me say both counsel agreed that is, the remedy can only be found in PI, where Esther does not apply.
Sorry, I'm really struggling to follow that. The statute defines the category of property it applies to. Two advocates come to you, they say, even though the statute says X, we agree on Y, and then the judge goes with the advocates, not with the statute.
The main reason why Esther was not applied here is because this case is premised on the fact that the respondent is in unlawful occupation, is an unlawful occupier, which is not covered by Esther. And not only that, where this house is situated, where the land in question, it is under the authority of the chief, yes, but it is land that was previously a farm area, which had been rezoned. I'm sure you can see somewhere where they say it's in the location of So it's neither a rural area or an urban area, as you put it, maybe peri-urban. But my dealing with the matter on the basis of pi is because this was the respondent was said to be in unlawful occupation. The case of the applicant was premised on the fact that she is an unlawful occupier.
Sorry, this is my last point on this. The Act, as I say, tells you that it applies to urban and peri-urban. They then bring an application in respect of rural land. Are you saying that you found that pi would be applied because the lawyers were not disputing it?
I'm not saying it's because the lawyers are not disputing it. I'm saying that I was convinced at the time that because of the unlawful occupation, the respondent was said to be in unlawful occupation, ESTA could not be applied. Not because they were saying so.
She's given her answer, Mr. Ngwenya.
Ye-
You
Yes,
may not
indeed,
like
Deputy
it.
Chair. I'm quiet
It is
from
what
now
it
on.
is.
Follow up, Deputy Chief Justice.
Sorry, where's that coming from? Oh, I'm sorry, Prof.
No, I'm also troubled by the reasoning. And perhaps maybe the judge may assist us. Good afternoon, Judge.
Good afternoon.
I just want to understand. Are you saying that when two legal practitioners appear before you and they argue on clearly incorrect basis legally, and they seem to be in agreement that whatever it is that they are agreeing on can be dispositive of the matter, you listen to them and you continue to dispose of the matter on that particular issue? Is that your response to Advocate Ngatobi?
I'm saying I was convinced when I was informed that, because I also saw that ESTA would not be applicable where the eviction is sought on the basis that the respondent is in unlawful occupation. And on that basis, I decided the case using, that's all I'm saying.
Okay, then it's fine. I will leave it there. But I'm just wondering as to why you then did not look at the common law as well. But anyway, I will leave it there. The Deputy Chief Justice.
Thank you, Commissioner Merumahai. Commissioners on the virtual platform, do you have questions for this candidate?
I have a question.
Please
Mrs.
ask,
Ndube.
please ask away, Commissioner Bernard.
Thank you. Ma'am, in your, the same case, Slela versus Lamini, my question is this, you referred the matter to oral evidence. So I've got two questions in that regard. The one question is, how did you find that experience? And I ask that as a result of your statement earlier that you haven't dealt with opposed trials yet. So obviously there was some oral evidence being presented in a civil matter. That's the one side aspect of it. But the second aspect of it is the dispute of fact that you saw there. Why could that not have been sorted out with the Plascon-Evans rule? You know, the way one deals with in applications.
The first part of your question, Commissioner Barnard, it was not the very first time for me to sit in a civil trial. As I indicated earlier, I have dealt with civil trials before, not in the High Court, but in the Regional Court. The dispute of fact here was whether the respondent, which version was acceptable, and I could not come to a conclusion that this one is so far-fetched or untenable that I can reject, being the respondent's version that in fact the land was allocated to the husband and herself. On the other hand, the applicant was saying the land was allocated to him and he gave it to the son to build the house there. That is what influenced me to say, because this is a very serious dispute that I cannot resolve on the papers. I should refer the matter for oral evidence. So the experience, how did I find it? It was just like an ordinary civil trial.
Thank you very much.
I
Thank you,
don't know
Lady
whether I
Lee.
answered. Is there anything that I left out?
Now you've answered. Thank you very much.
Anyone else on the virtual platform? All right, Ms. Mogwera, thank you for making yourself available for this vacancy. You are excused.
Thank you so much, Justice Maya.